Hello, and welcome to the DC Bar Pro Bono Center's webinar, Privacy and Accessibility Considerations for Web and App Development. I'm Christine, a managing attorney with the Pro Bono Center's nonprofit and small business legal assistance programs. As we begin, first, thank you to my colleague, our associate manager on the team, Lauren, who's done all of the behind the scenes work to make today's webinar possible, from registration to logistics and technology. A couple of rules, logistics, how this will work. If you're joining us live, know that this webinar will be recorded. You can come back, watch it again, send it to your friends. Also, right now you have immediate access to the slides in the GoToWebinar control panel. Both the slides and the recording will be emailed to you in the next few days. If you have questions as we're going, please send them in the questions box in your GoToWebinar control panel. Send them as we go, and if they make sense to ask in the moment, we will do them then. Otherwise, we will wait until the end to try and get to as many topic-appropriate, relevant questions as we're able. And this is an educational webinar, so please do your best to keep questions general and not based on your business's exact facts, so that you're really asking for legal advice based on your unique situation. Okay, today's webinar, why we are all actually here. We are joined today by Brandon Johnson. He is a partner at Davis, Wright, Tremaine here in DC, and he is an expert on today's topic. We are going to learn about some privacy and accessibility laws and frameworks that businesses operating and existing in a digital world really need to be aware of to figure out what applies to you, what doesn't, and understand the sort of mishmash framework for all of it. So thank you for joining us, Brandon. We are very fortunate to have you, and I will now turn it over to you.
Thanks, Christine, and it's great to meet you all. So moving to the first slide, it seems like it may be taking a little time, but I guess while it's transitioning, today our topic discussion will be on privacy and accessibility considerations for web and app development. This obviously concerns kind of two principal areas of interest and concern for the developer community. And as such, hopefully we'll provide some great benefits to you during today's presentation. As Christine mentioned, I'm Brandon Johnson, a partner at Davis, Wright, Tremaine here in DC. I've included my contact information in case you have questions or want to reach out after the presentation. So as any good attorney, I like to sort of set the agenda for the presentation. And so we'll start with an overview of key authorities, considerations, and requirements in privacy and accessibility law that are relevant to web and app development. And then we'll move into a discussion of certain best practices and tips for ensuring compliance and general good user experience as relates to these two issues. So first, turning to privacy, it may be helpful just as a point of background to step back and explain what the privacy regime is like here in the United States and how it may differ from other places. So unlike, let's say, in the European Union, which has a very robust sort of general privacy regime, to date, there has been no federal privacy law of general application, meaning that rather than having a single law that's intended to sort of attack privacy from a high level of generality, instead the US has so far taken an approach that really centers privacy requirements on a sector by sector basis, and we'll get into some of this later on, but there are kind of health privacy laws that pertain to student privacy, laws that pertain to financial privacy, and so it's a little bit of a mishmash. As you can imagine, and kind of is represented by these various colored states, because the federal system is sectorally oriented, that has left to the states and localities the obligation to kind of fill in the gaps. And so there is a kind of wide patchwork of various requirements in various states and localities that deal with a host of privacy and cybersecurity related issues. One thing to note, just as almost like as a definitional point, is that we'll be discussing today some terms. I'll try to explain them as I go, but obviously feel free to raise a hand if something isn't clear. But one term that will be key to today's privacy conversation is personally identifiable information, or PII. And that is a term that sometimes is referred to as personal data in some regimes, sometimes PII, but essentially covers any information that either used alone or in combination with other data can identify an individual. And so this could be anything from your name, email address, to credit card information, to even things like race, ethnicity, religion. So it can cover a wide range of data types. And PII is often a focus in the various privacy laws that we'll be discussing. So just wanted to give you that background before we jump into things. So turning to relevant authorities, I'd say perhaps the most foundational law in this space, although ironically not one that is expressly directed towards privacy, is the Federal Trade Commission Act, or the FTC Act. This act was passed decades ago and was really geared towards addressing unfair and deceptive trade practices. And in particular, a particular section of that act, called Section 5, prohibits unfair, deceptive acts or practices in or affecting commerce. So the idea here is, if a business or person is engaging in activity that is, likely to cause injury to consumers, that is likely to mislead consumers, that the government obviously doesn't want to facilitate that type of activity, and so therefore has prohibited it. I've put here on the slide so the definition as to how one construes unfair and deceptive. But as I said, broadly, anything that can be deemed sort of likely to confuse or mislead consumers, particularly if there's material impact, will likely fall within either unfair or deceptive under Section 5. So as I mentioned, Section 5 was designed without reference to what people typically think of these days as sort of data privacy, digital privacy. Nonetheless, because of the general prohibition on misrepresentations and misleading statements, companies over time have incorporated language in privacy policies that they've published, and I'm sure you've seen these, where they sort of describe their privacy policies, how they collect data, with whom they share data, the various bases on which they process data, et cetera. And those statements, if misrepresentative, could run afoul of Section 5 of the FTC Act. And so it's important to make sure that if you have a privacy policy or there are kind of privacy practices that are being relayed to the public, that those be accurate and comprehensive. Obviously, when things are not accurate or comprehensive, you may hear the FTC come knocking. The FTC is the Federal Trade Commission, the commission for which the FTC Act is named. And that is an independent bipartisan agency who has kind of a dual mission of protecting consumers and ensuring competition in markets. And so this area of work tends to fall in the consumer protection domain, but just noting that its ambit of authority is broader. And so there have been many actions by the FTC in recent years targeting companies, large and small, in relation to their privacy and security practices.
Brandon?
Oh, yeah.
A small business doesn't have a privacy policy or privacy practices, or everything is internal and it's not communicated to customers or clients. Do they need to worry about the potential of those practices violating this Section 5?
Yeah, that's a good question. So we'll get into this a little bit later. Because the sort of privacy regime is generally state-led, depending on the state in which you operate, or even probably more accurately, the consumers to whom you direct your websites and apps, that may beget different requirements. So, for example, in California, you need to have a privacy policy that's publicly facing. Other places, including DC, doesn't have that specific requirement. So I'll say, one, it depends on the jurisdiction that you're operating in. But two, and I think more generally, even where there's not a express obligation, I think increasingly consumers expect, at least some reasonable statements as it relates to how their data will be used and with whom it will be shared. So I think it's still likely best practice, even if it's not required. But as I mentioned, in many cases, it actually may be required to have a publicly facing privacy statement.
Okay, wonderful and very helpful. Thank you.
Yeah, no problem. So that's the FTC Act. And like I said, very sort of foundational and kind of broadly applicable to any commercial enterprise. As you know, it doesn't, well, at least there's an argument that it does not cover nonprofits because it only is intended to sort of address commercial activities. So if you're a nonprofit, there may be a little bit of a different analysis there, but for anything else, and again, large, small, B2B, B2C, you are likely covered by the FTC Act. Turning to a couple of specific subject matter areas that are covered by privacy law. One that is particularly relevant if you provide services to children is something called the Children's Online Privacy Protection Act, or COPPA. This act applies to commercial websites and other online services that are directed at children under 13 that collect and use PII for those children, or notably operators of general audience websites, so those websites and online services that are not expressly directed to kids, but where those operators have actual knowledge that they are collecting, using or disclosing PII from children under 13. So you can imagine if you have a general a website of general applicability, and someone in the registration process types in, they're born in 2015 or something, then that should clue the operator to the fact that that person's not 13, and therefore COPPA may apply. And the purpose, understandably, behind COPPA is really to ensure that children, particularly those that are most vulnerable, namely those sort of under 13, are especially protected in their online activity. And so, among other things, and this actually goes to the question Christina asked, if you have a site either directed to children under 13, or that you're collecting information from children under 13, you're required to post an online privacy policy describing information practices for PI collected from those children. You have to give notice to parents and obtain consent from those parents before collecting their PII, and also give them the ability to sort of opt out of that collection. So again, this is not necessarily applicable to all sites, but if you have sites or apps that are directed to kids under 13, then this will be relevant. And I should know that the COPPA is enforced by the FTC. So the same note I mentioned on the prior slide about the FTC sort of taking enforcement actions, which could lead to financial penalties or what are called injunctive relief. So sort of potentially shutting down the service or taking other acts to restrict it. That all applies here as well. Another act that is often relevant is somewhat wordy, Controlling Assault and Non-Solicited Pornography and Marketing Act, more commonly referred to as CAN-SPAM. I think they likely thought of the acronym and tried to create a backronym here. But the purpose of CAN-SPAM is to regulate commercial emails, so emails that have primary purpose of commercial advertising promotion, to regulate the reliance of those emails to ensure that people's privacy is respected. And so not only this CAN-SPAM Act applies to both business to consumer, so your typical consumer-based products, as well as business to business, or B2B. So whether you're sending commercial messages to enterprises or individuals, this applies. And to the requirements, which listed them here, more details if you were to look at the act. But essentially, the CAN-SPAM Act bars the use of any false or misleading header information or deceptive subject lines. If you see sort of, kind of weirdly constructed subject lines that are tend to kind of entice folks to engage in some kind of commercial transaction, that's not allowed. It is required to identify the ad as an ad or some other kind of commercial communication. You have to tell recipients where the sender is located, and there has to be a way for recipients to opt out of future communications, and the company has to honor those requests promptly. So if someone were to, I'm sure you've seen these unsubscribe toggles on emails, you're required to respond to that accordingly, and therefore respect the opt-out. One thing to note is that can spam, although obviously applies to the relevant entity that is doing the advertising or commercial activity, even if you were to say hire another company and delegate that responsibility, kind of like say through a marketing agency, that will not absolve you of responsibility under can spam. So it's still the ultimate, might say, kind of marketing entities requirement, even if the actual act of marketing and advertising is, delegated to a third party. And lastly, just like the other two acts we discussed, this again is enforced by the FTC. So everything we talked about before applies here as well. So turning to DC, given that this is after all a DC law clinic, DC doesn't have a general privacy law, so it's sort of like at the federal level, there's no law of general application. However, there is a breach and notification law that DC has that, among other things, requires businesses that experience a data breach. So that's generally a term that users refer to in kind of unauthorized access or disclosure of PII. That if that happens, the affected entities required to notify affected individuals whose PII has been compromised, as well as the DC Office of Attorney General. So you have an affirmative act to notify regulators here, which obviously generate further inquiry and possible enforcement. The breach notification law also specifies things like the specific content that you have to have in those notices, the time frame by which you need to send the notices, and the method of notification. So it's important to make sure, either with counsel or otherwise, that you're aware of those various requirements, because if you don't send the notices timely, or you don't send the notices with all the information that's required, even if you technically have sought to notify people, it may not be sufficient to comply with law. It can open you up to possible exposure there. The last thing is that it requires covered business to implement reasonable security safeguards. So in addition to obviously notifying people in the event of breach, the aim is to ensure that sort of this doesn't happen again. So make sure that businesses have robust security measures here. There's something called the Consumer Protection Procedures Act, or CPPA, which permits a wide variety of deceptive and unconscionable business practices. It's sort of similar to the FTC Act. So again, although not expressly privacy related, that may have import here. And then lastly, courts in DC recognize the common law tort of invasion of privacy. A tort is basically a legal wrong, essentially, and common law sort of refers to legal obligations that arise out of sort of judicial decision making, so not by statute. And so there have been cases in the past that have brought invasion of privacy claims for digital privacy losses. And so, again, nothing that's specific to privacy. There are a number of ways in which privacy can kind of spill into a DC business's profile here. So that was a very quick speed run through privacy considerations and authorities. We are now turning to accessibility. And just as we can point of definition, accessibility is a term used to refer to the access by people with disabilities to various products, services, and facilities. The most perhaps notable and well-known accessibility law in the United States is the Americans with Disabilities Act, or the ADA. This was enacted almost 35 years ago and intended to ensure broad access to people with disabilities in various domains of American life. And so here on the screen, noted a couple areas employment. So if you have 15 or more employees, you're subject to certain accessibility requirements. State and local governments have certain obligations. And then most notably, what will comprise most of our discussion here today, public accommodations. So those are basic places that are private businesses that offer goods and services to the public. Those are also covered under the ADA. And under Title III, which concerns public accommodations, covered entities are required to provide people with disabilities reasonable modifications, so sort of accommodations essentially, as well as auxiliary aids and services. So these are things like captioning or sign language interpretation, Braille, that are basically the tools by which people with disabilities can communicate with the relevant public accommodation. So you can imagine, given that the ADA was adopted in 1990, the then fairly nascent internet was not really on the minds of the congressional drafters. And as a result, as defined, public accommodation in the ADA itself refers expressly to 12 categories of places that are generally situated in the physical world. So things like banks or stadiums and arenas, restaurants, barbershops, other places of recreation and commercial activity. And so over time, the question arose as to whether or not the ADA applies to the locations or platforms beyond the physical world. And that has been an area of debate really for the last at least 20 years. Courts in the US have taken differing opinions on this. Some have held essentially that the ADA says what it says. It only speaks to these physical locations, so therefore its application only applies to those physical locations. Others have taken the opposite tack and said, well, the spirit of the ADA is really to ensure greater access for all, and we now live in a modern digital economy, and therefore we should apply the ADA even where there is no physical connection. And then a third, let's say, philosophy that's arisen is kind of the Goldilocks, which says that you have to have a nexus or connection between a physical place that's covered by the ADA and an online service. And so that's, for example, the law of the land in the Ninth Circuit, which is a federal court of appeals that covers, among other things, California, Washington State, Oregon. So in those jurisdictions, for example, there's actually a famous case called Domino's versus Robles, where Domino's was sued for allegedly having an inaccessible website and app, and the court there found that, well, there are Domino's restaurants that one could go to and through which people effectively are placing orders. So even if you're using an app or website to place the order, there's enough of a connection to a place that's otherwise covered by the ADA, and therefore you're covered. But again, that's a California case. The rules depend on where you are, and the Supreme Court, when prompted to resolve these disputes, declined somewhat unhelpfully. So we live in a little bit of a mishmash situation currently. The ambiguity here and differences of case law has led to an avalanche of litigation and regulatory activity in the space. There's an organization called UsableNet that does an annual survey of web accessibility lawsuits. And so this is a little bit dated, given it's from last year, but just last year, as an example, a little over 4,600 web accessibility lawsuits were filed, which was more than 2 times the number just 5 years prior. I don't know what the numbers are for this year because we're still in this year, but I imagine, and then having looked at this for the last several years, the trend tends to just move up and to the right. So there's certainly an area of high activity. And I should note, the Department of Justice is the regulatory agency that has enforcement authority over the ADA, but unlike in other areas of law, private litigants or private individuals can actually sue under the ADA. And so there's obviously even greater incidence of litigation activity as a result of that. One thing, just as a additional perhaps note of future casting here, that the DOJ earlier this year adopted web accessibility rules under Title II. So that you recall from the last slide, pertains to state and local governments. So state and local government websites and apps have to be accessible to people with disabilities. They've not made any similar action with respect to Title III, which is the places of public accommodation section. But given the Title II rulemaking, I think most folks who cover this area reasonably believe that there may be some activity on the horizon. So again, something to look out for in future years. So you may be asking yourself, well, okay, if there's no formal, except for Title II, no formal web accessibility requirements, the case law split across the various jurisdictions, how does one determine whether their website or app is accessible? And the answer to that is the Web Content Accessibility Guidelines, or WCAG. These are guidelines that were developed, I think initially maybe around 20 or so years ago. They've been updated every 4 or 5 years, that are voluntary guidelines that set out criteria for ensuring that particularly websites and apps and then increasingly other types of platforms are accessible. And so although they're voluntary, they've been broadly adopted by industry, courts, regulators, and in some cases actually incorporated into laws. So they, in many instances, actually are not voluntary. They become de facto law by way of incorporation. But in any event, even if not incorporated, these are the sort of the gold standard when it comes to accessibility, particularly in the United States. One just thing to note, you'll see here on the screen, this says WCAG 2.2, which is the most recent version of WCAG adopted last year. There are different versions of WCAG, so there's a 2.1, a 2.0, et cetera. Each successive version doesn't override the prior version. So if you're compliant with WCAG 2.0, then that means you're compliant with WCAG 2.0. It doesn't necessarily mean you're not compliant. But I guess conversely, you can't say you're compliant with 2.2 and only comply with 2.1. So the kind of standalone requirements with respect to versions, but you have to be accurate as relates to how you relay this information to the extent you do so. The last point is that in addition to different versions of WCAG, there are different levels of conformance. So there's a single A to double A to triple A kind of spectrum, with triple A being the highest level of compliance and single A being the lowest. And so as you can see here, even determining what compliance means can take different forms. It could be WCAG 2.0 AAA or WCAG 2.1 AA. It's a lot of flexibility here, but regardless of the path one takes, it's important to know what the requirements are and to make sure that you abide by them.
And are these requirements available for free online for somebody to just download, or do they have to pay or get a membership in order to access it?
Yeah, that's a good question. This is actually available for free. So probably the easiest way to find them, probably should put a link in the deck, but the easiest way to find it is type in WCAG into, say, a Google search, and you should be able to find both the landing page for WCAG, but also the various versions of WCAG. Like I said, 2.2 is the latest version, but you can find 2.1 or 2.0. And the landing page actually does give, I think, a reasonable overview of WCAG, what it means, what the various levels of conformance mean, how one can interpret things. They actually, for each of the criteria, there's the criterion itself. So, like live video and audio recordings should be captioned. But in addition, there's sort of these like guide breakouts that tell you, well, what does this actually mean in practice, or how would one achieve this? So it's a helpful resource. But yeah, this is all free and available to access online.
Awesome, thank you. Also, on the note of these guidelines, you explained that they are seemingly quite user-friendly, right? It explains sort of what they mean and what implementation looks like. But are you aware of any sort of gaps that are not filled by the guidelines of, sort of emerging accessibility needs that businesses should be aware of?
Yeah, that's a good question. So I think the best way to answer that question is to say that I think that the guidelines are fairly comprehensive. I would say they're probably most user-friendly to engineers. I mean, you can read them, but some of the requirements are somewhat technical in nature. But I think if you have a person who kind of manages websites and apps, they probably can ascertain what's going on there. In terms of what's covered, like I said, it really covers predominantly website and app accessibility. There actually is a draft, sort of not technically WCAG, but an XR guideline. So for extended reality, if you have, for example, virtual reality, augmented reality, mixed reality, the W3C on the screen here, the top right corner of this picture, is the World Wide Web Consortium, which is the entity that makes WCAG. They put out guidelines on XR that are not covered in WCAG, but they're only in draft form, so they're not formally published. But that's an example where WCAG, does not go at least to the full extent as, let's say, the XR guidelines go in relation to those types of technologies. And then there are also, we'll do this in a couple slides, requirements that are applicable to various entities that are not in WCAG. And so one which we'll talk about in a second is the 21st Century Communications Video Accessibility Act, or the CVAA, which has certain requirements that pertain to video and certain communications tools. And so even though there may be some overlap, complying with WCAG may not get you all the way to compliance with, let's say, the CVAA, because the underlying requirements differ in some respects.
All right, thank you.
Sure. Oh, I guess so. We got there faster than anticipated. So, as I mentioned, the CVAA is a law that was intended to update what was the sort of existing accessibility laws to cover modern communications and video technologies. Unlike some of the other acts that we talked about in the privacy sector, the CVAA is enforced exclusively by the FCC. So there's no what's called private right of action, meaning there's no ability for individuals to bring suits. But the FCC does have pretty broad remedies that they can use to enforce this act. And as I said in the last slide, this is different than there's some similarities, but it's different than WCAG. And so therefore, where you have relevant technologies that fall within the scope of this law, this will be kind of your Bible, essentially, as it relates to what you have to do to comply, not necessarily WCAG. So the CVAA covers a number of different areas. I don't think we'll have time to go to all of them today, but I'll try to highlight in this slide, the next few that follow, some common areas of relevance, particularly for apps and websites. And so one is something called Advanced Communication Services, or ACS. ACS, as defined in the CVAA, refers to basically types of real-time two-way voice, text, and video communications. So specifically, as noted in the first bullet here, interconnected and non-interconnected VoIP, so voice over IP, so voice calling for the internet, either through what's called the public switch telephone network, so we make a call to your parents on their cell phone, or through non-interconnected, which is sort of a closed network, so think of like a Teams calling or Messenger, those would be considered VoIP. Electronic messaging services, so those are basically real-time text communications, so emails, texts, group chats, those kinds of things. And then interoperable video conferencing services. Notwithstanding the word interoperable, this actually applies to basically any service that enables real-time video communication capability. And so again, Teams, Cisco WebEx, those kinds of products would be covered here as well. In terms of the requirements, providers of ACS product and services have to ensure that ACS is accessible as well as, I think, usable by people with disabilities, and that has a particular term of art that requires, for example, ensuring that people with various disabilities in various cohorts, so those who have visual impairments, those who have mobility limitations, speech limitations, cognitive disabilities, that they be accessible to people with disabilities. There is an exception, which is achievability. So as you can see here on the second bullet, you're required to comply if it's achievable, and that requires sort of an analysis of kind of the financial and administrative lift that it takes to reach compliance. So this may be helpful if, let's say, you're a small business with not a lot of resources or not a lot of financing. There may be ways in which you can make the argument that complying with the requirements is too cumbersome. But again, it's seen as what one would say in the legal sphere is an affirmative defense. So you can't just say that and say, hey, I'm good. It's really only if you get, say, if a complaint is brought against you, can you kind of invoke that exception, and still requires some evidence. So you may have to produce your finances, or show your engineering capabilities to make out that exception. So not a slam dunk, but something just to consider if you really are constrained resource wise. One thing that is helpful, however, is a separate apart from that overarching exception, is that covered entities can actually rely on third-party solutions, so long as they're made available to the consumer at either no or very low cost, as well as you can use existing peripheral devices and other equipment, like, say, screen reader technology, to achieve access. So the rules do allow covered entities to rely on third-party services and solutions. You don't necessarily have to define everything on a first-party basis, because that obviously would be very expensive. But if you do use third-party solutions, they just need to be available, like I said, free or low cost, and generally interoperable with various assistive technologies. The final point here is we've been talking so far about what are typically called technical requirements, sort of the substantive, how do you make this accessible requirements. But there are other administrative requirements, like you have to maintain certain records, you have to make a certification to the FCC once a year, as well as information requirements that apply. So I note that because this regime is not simply one of substantive compliance with accessibility, but also making sure you're keeping the relevant records, that you're relaying the relevant information that is necessary under the rules as well. So another area that's covered by the CBA is the online video. And so video programming that has appeared on U.S. television, meaning sort of like broadcast, cable, or analogs of those. So any video programming that's appeared on U.S. television with captions generally has to be captioned when relayed online. I stress the television part because online only video and user-generated content are not covered. So if you have, say, you have an app that provides streaming services that only provides content that appears online, so like a YouTube or something like that, you wouldn't be covered. This would only cover things like if you could stream Friends or Frasier or other shows that actually appeared on TV. Then you're required to caption this content when it gets distributed online. And I should know that I didn't know this here, but there are rules that pertain to full-length programming, so like full episodes of TV, full movies, as well as video clips. So if you have clips of video or excerpts, the rules somewhat differ, but those also have to be captioned when those conditions are met. So it covers a broad swath of video programming. The obligations that apply in this context turn on the role that one plays in the environment of video programming. So video programming owners, which are basically the entities that either own or license video programs, they have to ensure that the program file, the video file that's being provided, has all the captions that are required under applicable law, with at least the same quality as those on TV. So it should not be a diminution in quality when it goes from TV to online. By contrast, video programming distributors, so those are the entities that basically distribute programming to the end user. Their obligation is to make sure that the captions that are provided by the VPO, video programming owner, is relayed intact to the end user. So again, it's sort of like the VPO provides the captions, and the VPDs make sure that the captions get to the end user. Like ACS, there are certain exceptions. The economic burden exception is sort of similar to achievability. It obviously centers more on economic burden than administrative burdens, but similar idea. But there is a separate exception for online closed captioning that allows certain what's called de minimis noncompliance. So, let's say you had 1,000 videos and one wasn't compliant. That may be sufficiently small enough to get a pass. But I should know that there's no threshold. So even that one, let's say that was the premier video in your video portfolio, even if it was just a single video, that may not pass muster. So just to know that there are exceptions here, but again, requires some doing to invoke them and rely on them. So I wouldn't lean on those as your first options, but just know that they are there in case it's helpful. So the last area I want to touch on concerns digital apparatus, and somewhat confusingly, the term apparatus actually is plural. So this, I guess you could call them digital apparatuses. But these are a reference to the physical device, or a device that actually plays video programming, video players on those devices, and notably for app developers, third-party apps that are either pre-installed on the device or that the manufacturer basically requires or directs the consumer to install after sale. And so if you fall within any of those categories, and you manufacture digital apparatus for use in the US, you're required to have certain accessibility features for people who are blind or visually impaired if certain functions are built in. And so if you have, for example, navigation like play, stop, fast forward, power on off, volume controls, if those are built into the device or the apparatus today, so it covers devices and apps, then those various features need to be made accessible to people who are blind or visually impaired. So this is another area of coverage, and again, most relevant for kind of video streaming platforms. But just wanted to note that in addition to the actual content, which is the IP closed captioning rules that we talked about before, this is the, might say, delivery mechanism, or the actual video players essentially that need to be accessible. Because as you imagine, sort of like having the key to the door to a hotel, even if the hotel is perfectly accessible, if you can't get into the hotel, the door is not accessible, the entrance is not accessible, then it doesn't matter. So this is an attempt by the FCC to ensure that the door is accessible. So on the DC front, accessibility law, sort of like in the privacy context, there are no specific, at least digital, I should have noted, digital accessibility laws in DC. There's something called the DC Human Rights Act that prohibits discrimination in places of public accommodation based on a number of protected traits like race, gender, nationality, etc., but also includes disability. So it's kind of like the ADA, but broader scoped to cover other traits. There have been cases where the courts in DC have found that the DCHRA does not cover online-only platforms. So if you only provide goods and services online, there's precedent that suggests that those kind of entities are not covered. However, where there may be a nexus between the physical place for a public conveyance, sort of like that Ninth Circuit Domino's cases I mentioned, you could be covered. There's a district court case, which is the lowest level court in the federal system. So maybe not the most definitive answer on this because the Court of Appeals supersedes them, but just know that there's still a possibility within DC, even under DC specific laws, that businesses that have typically a nexus with, say a pizza restaurant or a bank or, a barber shop, that if you have online services that consumers engage with in connection with those places of public accommodation, that you may be covered there. Finally, just wanted to flag that we've been discussing really mainly federal laws, obviously with some DC exceptions, that are intended to be either generally applicable or ones that probably have the most relevance for most web and app developers. But I wanted to flag on this slide that this is just a small piece of a larger puzzle. There are other subject matter specific laws. So there are laws that deal with financial privacy, health privacy, student privacy. There are rules that pertain to the accessibility of products and services and websites that are procured by the federal government. And so Section 508 of the Rehabilitation Act may come up if, for example, you are providing, say, web services or selling products and services into the government, that they have their own obligations under 6508. And so that by extension means that, the vendors that they use to provide product services will need to be accessible in order for them to satisfy their obligations. In addition to DC, there are other state laws. I should note, even if you're DC based, if you have a, say, website of general application, or let's say even more so that you target consumers in different states, then you may be subject to those other states' laws. And so there are other state unfair incentive acts and practices, or UDAPs, that are kind of like the FTC Act that can apply. The California Consumer Privacy Act, we discussed this earlier a couple slides back. That's sort of a very robust privacy regime in California that has a number of requirements that entities that either operate in California or target California citizens have to comply with. And then state and local accessibility laws that actually, unlike the ADA, often have additional remedies. So, for example, the ADA only permits plaintiffs to recover attorney's fees, but the UNRAC, for example, California, and there are others in other states, allowed for damages. And so you'll see often in accessibility cases claims brought under both the ADA and state laws, because it gives them more, bites of the apple and greater remedies. And lastly, so far we've been talking really only about sort of the US, but to the extent you have any operations globally, there are other laws, the General Data Protection Regulation, you may have heard of GDPR. It's a really kind of robust omnibus privacy law in the EU. There's actually a accessibility analog to that that's coming into effect next June, and then other standards. So the EN 301549 is sort of a standard for accessibility that's often a comp for WCAG or Section 508. So you may see reference, for example, to EN standards in addition to some of the other standards we discussed earlier today. So in the couple minutes we have left, I wanted to turn to some sort of practical next steps to kind of how you can think about web and app accessibility and privacy. Obviously, not expecting anyone to remember virtually anything for the last 40 minutes or so. But these next slides will hopefully help to kind of key into some concrete things that you can do that will hopefully get you on the right path. So starting with privacy, there are a couple of key principles that are helpful to be aware of and sort of follow, regardless of where you're operating and kind of what you're doing in terms of your business. The first is data minimization. So this is the idea that you should only be collecting what is absolutely necessary for purposes of relaying the product and services that you are providing. So if you have a need to collect phone numbers for some reason that's relevant to your business, great. But if you're collecting, say, address information for no purpose, that's not so great. And obviously it can lead to possible issue if, let's say, that data is breached and otherwise disclosed on an unauthorized basis. So make sure you're only using what you need to use is really the first point. I guess related to that first point, making sure that the purposes for which you are using data are made clear to consumers and maintained. So again, you can imagine if you say we're only going to do X with your data, but then you actually do Y and Z, that can cause problems and possible liability down the road. Transparency is another thing. We've talked about some regimes actually require privacy statements, but even when they're not required, making clear that you're kind of clearly and in non-legalese language explaining to customers how you use their data, with whom you share the data, any sort of exceptions to general rules, so that way there's no Section 5 possibility that there's enforcement that can be raised against you. The fourth is user control, so making sure that you actually give users very easy to find and use consent options, so they can opt out if they don't want to, say receive emails as an example under can spam, or if they want to tweak their privacy settings, just to give them as many tools as possible to be able to tailor their experience. And the last point here is to think of privacy as kind of a lifetime obligation and/or enterprise. So at every stage of the product development process for websites and apps, but even thereafter, making sure that you integrate privacy and privacy controls at each stage is really important. So those are general privacy tips. Data security is, often lumped in with privacy, but technically something different. That refers sort of the security of data against unauthorized access, basically. And so here are some examples of things that can be useful. Increasingly we've seen complex and multifaceted password and authentication protocols. Make sure that you restrict access to sensitive data, so things that say pertain to health or financial information, social security numbers. Those, in many instances, in certain laws, will have actually higher scrutiny and higher requirements applied. And so making sure that you segregating that data that is really managed tightly is important for avoiding liability. Securing the data when it's stored or in transit, typically via encryption, is a good way to make sure that things don't get disclosed or otherwise accessed inadvertently. There are a number of standards in the security space. So I've listed here a couple. PCI DSS is really about payment cards or credit cards, but ISO 27001 is a kind of common industry standard for cybersecurity, and there are others that you may want to look for. And then lastly, making sure that you're testing for common vulnerabilities and you're auditing your security controls, just to make sure that you're doing what you say you're doing, and if there are issues, that you're able to identify them and remediate them as quickly as you can. On accessibility, some of these same tips apply. So again, thinking of accessibility from the very beginning of the product lifecycle and making a roadmap to ensure that the products are accessible over the course of the development of, say, the website or app. Something that's perhaps unique to accessibility is that you're dealing obviously with communities who have certain needs. So one way to best address their needs is to talk to them. So it's helpful to solicit the opinions of vendors who, for example, may do accessibility audits or provide accessibility counseling, as well as people with disabilities, to determine how best to serve their needs. Just like in the privacy section, making sure that you're doing periodic audits to identify and resolve issues that may arise with respect to accessibility compliance. And then lastly, and this kind of pertains to some of the exceptions we talked about, if there are technical or administrative challenges, we don't have any money, or we only have one person on our engineering staff, it's going to take 18 months to make this fix. Documenting that information can be useful in the event of a complaint or other inquiry, because again, it's easier to invoke the exception when there's contemporaneous documentation that didn't just appear the day the complaint arose. So having a good sort of what we'll call record keeping hygiene is important here as well. And I guess lastly, if you have questions, it doesn't have to be me, but if you have questions or concerns, or trying to think of, okay, well, what does this WCAG thing mean again? You can always consult an attorney who can advise on these type of issues, both on the privacy and accessibility sides. So with that covers my part of the presentation, but I'm happy to field any further questions or comments folks have.
All right, so we have a couple of questions, and if you're listening and live and have some more, feel free to type them in the chat. A really interesting one. So we mentioned, and you went through really well explaining how both privacy and accessibility laws can be super different depending on the state, right? All across the spectrum, and the obligations can be different for a business. They might have some, they might have none. How does a small business figure out which state's laws might apply to them, other than, maybe DC, Maryland, Virginia, the obvious ones?
Yeah, so that's a very good question. I think there are, at least in my mind, again, states may vary, but I'd say generally there are sort of three ways in which you can, effectively fall within the jurisdiction of a state's laws. One is if you're based in that state, right, or if you have operations in that state, from a physical matter. So if you have an office, even if you're DC based, you have an office in New York or some outposts in Chicago, that will likely trigger jurisdiction over those offices. The second way that often comes up is if you are collecting data. This is probably more relevant to the privacy area. Collecting data on citizens or residents of another state. So if you're doing some in DC, if you say have users in California, you have their data, then I'm not an expert on all various triggers for applicability, but that could be a basis upon which you may be covered, let's say, under California Consumer Privacy Act. And then lastly is if you are directing sort of your services, website, app, etc., to other jurisdictions. So if you expressly say have a website that's like intended to be geared towards like Texans or something, I don't know, then even let's say if you don't have any users there, just your projection into the stream of commerce that is Texas may be a basis upon which they can try to achieve jurisdiction. So again, it varies, but I think certainly if you have operations physically anywhere, that's like a near certainty that you're covered. And then if you instead of collecting information or directing activity, it's possible you're covered there as well.
Okay. Next, a lot of the sort of technicalities, on both accessibility and privacy are things that some businesses will handle in-house, developing the framework, the website. Some of it maybe they hire contractors to handle. If an independent contractor, a company that they hire, does not follow some of the standards set out by law related to those, is the business still liable? Would the business still be sued and in trouble for not being accessible, not storing their data private correctly, or following the regulations?
Yeah, so that's a good question. The answer is, I guess as often is the case, it depends. So there are some, for example, in California, this is not yet adopted, but there's a bill that's pending that would extend liability for, say, inaccessible websites and apps to both the provider of the website and app, but also to the so-called research service providers, which include web developers, like Expressly. So meaning, in that case, the web developer would be liable, but also the underlying, sort of provider of the service. In the privacy sector, we talk about where scenarios where you can't simply just delegate. Let's say in the can spam context, you can't delegate to an email marketer your legal liability. So if things go south, even if you're using an ad firm, let's say, you are still liable as the sort of ultimate provider of commercial communication. So that may not always be true in every instance, but I would get thinking sort of conservatively and being most protective. I think you should reasonably assume that if there is an instance of issue that can cause liability for the business. The one thing I will say, just as a matter of contract, is that even if you're liable as a matter of law, you may be able to kind of risk allocate contractually. And so this is not probably worth going into too much detail today, but there are provisions called indemnification provisions in contracts that essentially say, if a third party sues me because of something you did, then you have to, cover my costs, or you have to defend me in litigation, or whatever the case is. So there are ways that maybe you can manage that risk contractually, but certainly where expressly stated, if the law still holds you accountable, then there's not really a good way to get around it as a legal matter.
Okay, wonderful. Well, it looks like we are actually at the end of time right now. And so I think that's probably a good place to stop with the questions. Thank you again, Brandon, for walking us through this landscape and getting everybody up to speed on some of the key things that they should be thinking about and complying with. Thank you to everybody joining us live and those of you that are listening to the recording. When you click out, we would really appreciate your feedback in the survey about today's webinar as well as future topics. And if you would like to check out any of our other content or sign up for one-on-one brief legal advice, you can do that on our website, lawhelp.org/DC/NPSB. lawhelp.org/DC/NPSB. Thank you all again. I hope you have a good afternoon.